January 31st, 2026, 9:42 in the morning. Inside a quiet federal courthouse, a clerk walks a thin stack of papers up to the bench. No cameras, no applause, no rally crowd chanting outside. Just fluorescent lights, the low hum of air vents, and a moment that Donald Trump's legal team spent years trying to prevent. 17 minutes. That's how long the emergency call with Trump's lead attorney reportedly lasted after the order dropped. 17 minutes for his team to process what the federal judge had just done. 17 minutes before the reality sank in that the one person they have spent years keeping out of the legal blast zone was now being pulled directly into the center of it. Because with a few signatures and a sharply worded ruling, the judge shattered one of the last invisible shields around Donald Trump's world. Melania Trump must testify under oath. No automatic spousal privilege. No quiet carve-out. No graceful way to duck the questions. A former First Lady, compelled to sit in a room, raise her right hand, and answer detailed questions about her marriage, her living arrangements, and the choices her husband made when he held the most powerful office on earth. For Trump's legal operation, it isn't just another setback, it's a breach. A breach inside the one fortress they thought nobody would dare touch. So, how did it come to this? Why did a judge go this far? And what does it mean when the person closest to a former president is ordered to talk and can't just walk away? If you think this is just about gossip or drama, you're not seeing the real story. What you're about to hear changes everything. To understand why this order hit so hard, you have to understand the role Melania Trump has played in Donald Trump's political and legal universe. For years, Melania has been the silent figure in the photographs, the carefully controlled presence at rallies, the one who rarely speaks publicly and almost never sits for long, probing interviews. While Donald Trump built a brand on noise, confrontation, and constant media warfare, Melania built something else: distance. Distance from his scandals, distance from his legal battles, distance from the ugliest headlines attached to his name. Every time a new lawsuit hit, every time allegations resurfaced, every time prosecutors moved a little closer, there was an unspoken rule within Trump world: keep Melania out of it. No sworn testimony, no depositions, no discovery demands digging into her private life. That distance wasn't accidental, it was strategy. You don't expose your most protected asset unless you have no other choice. And for years, even when Trump himself was forced under oath, even when his companies turned over boxes of documents, Melania stayed off the witness list. Until now. This order didn't drop out of nowhere. It grew out of a strategy that was supposed to intimidate, to silence, and to control the narrative, one that spiraled into exactly the kind of discovery nightmare Trump's lawyers have spent their careers trying to avoid. It began, like so many modern political scandals, with words: a journalist, a commentator, or an author, someone willing to publish deeply uncomfortable claims about the Trump family, their money, their connections, and their past. Melania's team responded with what powerful people often use when they want to shut someone up: defamation threats, letters, warnings, demands for retractions. The message was simple: take it back, or we'll see you in court. But here's the part most people outside the legal world don't fully grasp. When you threaten to drag someone into court for defamation, you open a door, and if that person decides to fight instead of fold, they get to walk through that door, dragging your life with them. In this case, the target of those threats didn't back down. They invoked protections designed to stop powerful figures from using lawsuits to silence critics. And once that happened, the question in front of the court wasn't just, did this person say something mean? It was, where does Melania actually live? How involved is she? And how much of her public narrative lines up with reality? That was the trigger. Not a tabloid story, not a Twitter rumor, a legal counterpunch that turned a threat into a full-blown fight. And buried inside that fight was something Trump's team never wanted to see: a judge willing to say, if you're going to play this game, you don't get to do it from behind a locked door. If this were just one messy case, one strange ruling, you could chalk it up to bad luck or a bad judge. But it isn't. It fits a pattern. Look back over the last decade of Donald Trump's legal history, and you see the same moves over and over: aggressive threats, big public statements about suing enemies, carefully calibrated denials pushed out through lawyers and spokespeople. But when you zoom in on the courtroom side, the transcripts, the motions, the orders, another pattern emerges. The line between political theater and legal reality keeps breaking down. Consider how often courts have had to step in to force testimony, documents, or compliance out of Trump's orbit. Subpoenas for emails and records connected to his inner circle. Judges warning that broad confidentiality claims were overreaching. Investigators asking again and again, who knew what, who was in the room, who signed off. And throughout all of this, one zone stayed mostly untouched. The intimate details of Melania's world, her private communications, her day-to-day residency, the financial web that surrounded her. That wasn't because nobody was curious. It was because everyone knew crossing that line would set off a political explosion. You don't force a first lady or a former first lady under oath without expecting backlash. So, the system bent. It turned a blind eye to certain questions, gave weight to certain claims of privilege, accepted certain assumptions without testing them too hard. This ruling breaks that pattern. It says, no more special bubble. If you want to weaponize courts to protect a reputation, then you're going to have to sit in that same courtroom and answer questions like anyone else. That's not just a personal humiliation. It's a systemic shift. No one person creates this kind of legal standoff. There's always a system around them. Inside Trump's orbit, that system includes lawyers who've made careers out of pushing privilege claims to their absolute limit, PR advisors who know exactly how to frame legal setbacks as political persecution, and allies who repeat the talking points until half the country starts to believe them. It also includes judges, some appointed by Trump himself, who have at times seemed unusually patient with delay tactics, broad objections, and sweeping claims of immunity. In this new case, a federal judge walked right up to the edge of that patience, then stepped over it. The ruling doesn't just say, Melania must testify. It dismantles a legal narrative that's been carefully constructed for years, that proximity to a president creates an automatic shield from basic accountability. The judge points to a narrow exception, one that allows spousal testimony when it's essential to resolving key questions in the case. That's not a loophole. That's the law saying, if you're central to the facts, you don't get to hide behind the title spouse forever. But here's what nobody saw coming. By pushing this far, by insisting on this testimony, the court isn't just testing Melania. It's testing the entire legal culture around powerful political families. If you're watching this, imagine what that means for every senator's spouse, every governor's partner, every billionaire's carefully insulated family member. If this ruling stands, that wall of off-limits starts to crack. Don't go anywhere, because the fallout from that crack is already spiraling inside Trump's legal team. Within minutes of the ruling hitting the docket, Trump's attorneys scrambled to file emergency motions, appeals, anything that might slow the clock down or carve out a last-second exception. Why the panic? It's not just about what Melania might say. It's about what she can be asked. Under oath, she can be questioned about where she was living at specific times, what she knew about certain financial structures, accounts, or transfers tied to Trump-connected entities. What conversations took place behind closed doors when scandals broke, when documents went missing, when legal threats were drafted. This isn't a TV interview. She doesn't control the questions. She can't just walk away if it gets uncomfortable. One scenario legal analysts are already gaming out goes like this. If she gives careful, minimal answers, she risks being confronted with documents or witnesses that contradict her. If she overshares or slips, she could accidentally expose patterns or conversations Trump's team has spent years denying. And then there's the darkest possibility. If prosecutors or opposing counsel can show that she knowingly lied under oath about finances, about residency, about what she saw or heard, she doesn't just embarrass her husband. She exposes herself to perjury charges. Think about that for a second. A former first lady, not just answering questions about her marriage in public, but potentially facing criminal exposure if the truth and the narrative don't match. No wonder full panic mode is the phrase people close to Trump's team keep using. If you're watching this thinking, this all sounds extreme, ask yourself this. If an ordinary person sued someone, made aggressive legal threats, and then fought discovery every step of the way, would a judge hesitate this much? Or is this what happens when the system finally stops treating power as a shield? As soon as the order became public, two realities snapped into place. On one side, critics of Trump and defenders of press freedom called it overdue accountability. They argued that if you try to weaponize defamation law to scare journalists and silence critics, you shouldn't be surprised when a court demands receipts. To them, making Melania testify isn't harassment. It's the inevitable result of a legal strategy that backfired. On the other side, Trump's allies framed it as a political hit job. They described it as an outrageous invasion into a first lady's private life, a new low in what they say is an endless campaign to destroy their family by any means necessary. They warn that if this can happen to Melania, it can happen to anyone connected to a political figure, regardless of party. So, who's telling the truth? Is this accountability or weaponization? The reality is uncomfortable. It can be both a necessary legal step in a specific case and part of a broader, escalating arms race where every side uses every tool to crush the other. But that's not the most disturbing part. The most disturbing part is what this does to already collapsing trust in the system itself. This isn't just about the Trump marriage. It's about something much bigger. We are now in a moment where the legal system is being forced to answer a brutal question. Does the law really apply the same way to people at the top as it does to everyone else? For years, the answer has looked like no. Endless delays, endless appeals, endless claims of immunity and privilege. For ordinary people, subpoenas and court orders aren't suggestions. If you're told to show up and testify, you show up, or you face serious consequences. You don't get to hide behind your spouse. You don't get to say, actually, that's private, when the issue goes directly to the heart of the case. This ruling drags that double standard into the light. If a former First Lady can be compelled to testify about her life and her marriage, what excuse does anyone else have? At the same time, if courts start pulling spouses into more and more politically heated cases, how long before every major political family is living in fear that one wrong lawsuit, one bad ruling, one determined prosecutor will drag their private world into public view? If you believe in due process, this should scare you. If you believe in equal justice, it should also feel overdue. That's the fracture. That's the conflict. And we're nowhere near done. You might be thinking, okay, but I'm not married to a president. Why should I care if Melania has to testify? Here's why. Precedent doesn't stay confined to the people it was created for. When a court expands an exception to spousal privilege in a high-profile case, that logic doesn't just vanish when your name isn't Trump. If prosecutors see a new path to drag spouses, partners, and family members into sensitive cases, they're going to use it. If civil lawyers realize they can pierce more privacy claims by pointing to rulings like this one, they're going to cite it. Imagine being married to someone under investigation and suddenly realizing that conversations you thought were private could be questioned under oath. Imagine being pulled into a deposition about financial decisions you barely understood at the time. Imagine being forced to choose between protecting someone you love and protecting yourself from perjury. That's not hypothetical. That's the real-world impact when privilege exceptions expand and when powerful test cases set new boundaries. If you're watching this, ask yourself, do you want a system where power buys endless protection and families at the top never face scrutiny? Or a system where courts, desperate to prove they are not afraid of the powerful, swing the pendulum so hard that everyone's private life becomes fair game? Drop a comment. How many people do you think will end up dragged into court because of precedents like this? Spouses, aides, advisors, who never thought they'd be on the witness stand. Here's what almost everyone is missing. This isn't just about a single defamation fight or a single ruling in a single federal courtroom. It's about the slow, grinding collision between three forces. Powerful political families who've treated the law as a tool, not a guardrail. Courts that spent years avoiding direct confrontation with that power, and a public that's losing faith in every institution at the same time. When you zoom out, Melania's testimony order becomes something else. A stress test. A test of whether judges are finally willing to say, no one is off limits when the facts demand answers. A test of whether Trump's long-running strategy, delay, deny, attack, threaten, still works when the person under pressure isn't just him, but his wife. And beneath all of that, there's another open loop nobody in Trump world wants to talk about. If Melania confirms under oath details that contradict Trump's public narrative about his actions, his documents, his finances. What happens next? Does she become a star witness in future cases? Does her testimony unlock new lines of inquiry prosecutors couldn't reach before? Does it fracture the Trump brand from the inside, turning private doubts into public evidence? Remember those 17 minutes we talked about at the beginning? 17 minutes of frantic calls, emergency filings, whispered conversations about what Melania might say and how much risk they can tolerate. Those 17 minutes weren't just panic, they were recognition. Recognition that once she sits down, once the court reporter starts typing, once the first answer is on the record, there is no rewind button. From today, the clock is already ticking. Legal commentators say that unless a higher court intervenes, Melania Trump will likely have to sit for sworn testimony within the next few weeks. That means lawyers are already drafting outlines of questions. Teams are already assembling timelines of where she was, what she did, what statements were made, and how all of it connects back to the claims at the center of the case. From here, there are three broad paths. She gives narrow, carefully scripted answers that limit damage but raise new questions prosecutors will chase later. She reveals more than Trump's team expects, either intentionally or under pressure, creating fresh exposure and new investigations. Or she tries to protect the narrative and ends up contradicting documents or other witnesses, triggering a perjury fight that explodes far beyond this case. None of those paths are safe. All of them deepen the crisis. And remember, this is unfolding at the same time as other legal fronts, criminal cases, civil judgments, congressional inquiries are circling around Trump's orbit. Each new sworn statement, each new deposition, each new ruling doesn't just live on its own. It plugs into a larger map. If this is opening your eyes to how interconnected these cases really are, you know what to do. Because the more people understand the stakes, the harder it becomes for anyone, left, right, or center, to pretend this is just another news cycle. So, where does this leave us? We are about to watch something unprecedented. A former First Lady, ordered by a federal judge, sitting under oath to answer questions that could directly implicate or exonerate a former president of the United States. If her testimony confirms the worst suspicions, it could accelerate legal and political collapse around Donald Trump in ways even his harshest critics haven't fully imagined. If her testimony downplays everything, it will still leave millions of Americans convinced the system bent once again to protect the powerful. Either way, something breaks. Trust in the marriage, trust in the courts, trust in the idea that there's any neutral ground left in American politics. The real question isn't just what happens to Melania, or even what happens to Trump. The real question is this: if it took this much pressure, this many years, and this level of national crisis just to force honest answers from the person closest to a former president, what else is the system still afraid to confront? How many other powerful families are out there right now, protected by the same unwritten rules that shielded Melania until this judge decided they no longer apply? If you want more hard, unfiltered breakdowns of moments like this, the ones that slip past the headlines but reshape the rules, stay tuned. Because this order, this testimony, this breach in the wall around Trump's inner circle is not the end of the story. It might be the opening chapter of something much bigger.